Good morning, good morning, good morning, and welcome to the Champion School of Real Estate, Rita Santamaria Quarterly Update. I was looking at the screen to see our different campuses as they come in to the program this morning, and it's always fun for me to see that Austin, San Antonio, Plano, Fort Worth, Houston, all three campuses, Galleria, that everyone is coming on board in order to allow me to say, first of all, thank you for your business, and then secondly, to have the opportunity to help you be a little more informed about what's going on in our real estate world. And the absolute goal of my quarterly update is to bring you new information so that you're up to date, as well as to let you know about some things that are either selling skills or particular rules, statutes, policies that will keep everyone out of trouble. And again, my goal is also to try to get something that applies to everyone. And kicking off my particular talk with you this morning, I hope that we do hit something for everyone, and I believe that we will hit something for everyone, because right away I want to give you a little bit of information of some changes that happened with this legislative session that apply to us as real estate licensees. I'm going to go a little bit further into that as we get through the economic update of our business in Texas. And so the second part of my talk this morning is really like 26 ways to lose your license if we were on the negative side, or to keep your license on the positive side. But in a nutshell, just a few things that you will see that will affect you when you actually see September 1 come around, and as well January 1 come around. And the first is for everyone, whether you're in residential, commercial, property management, what will affect all of us is the information about brokerage services form will now be in 12-point type. And those of you that are in class right now getting your license and taking the prep, you know that you're tested on currently 10-point type, but it was changed and became a new rule that it will be 12-point type. Now, how will that affect you for your prep? You don't have to worry about that, because as Pearson VUE has changed the state portion of the prep, they allow us to get ready so that our students know, and it's in our textbooks, that IABS, that testing question, the answer will be 12-point type. For those of us that have been in the business for a few years, we actually can't remember when we didn't have to use the word promulgated form. Well, today it's no longer promulgated form, in that they changed the word promulgated after all of these many years to what it really is, mandatory. So that word promulgated will be changed to mandatory. And we also have noticed that just about every single one of our current contract forms have been edited, changed, updated. And so the first of the year, we will see just a few changes that the Broker Lawyer Committee brought together in order to change all of our contract forms. It's not going to happen right away, but indeed, every single one of them have some updates and changes. So I hope that we have something for everyone. And what, again, will affect everyone is what Governor Greg Abbott signed, which is Senate Bill 2212. And it changes a bit of our advertising regulations. And it removes the current requirement that the advertiser must be identified in each advertisement as a broker or agent, and clarifies that an advertisement is misleading if it fails to include the name of the broker. However, with this new change, it means you don't have to put the TREC initials on your advertising. You don't have to put your license number on the advertising, and you don't have to use the word agent. What you do have to do is make sure that you identify who your broker is. So, frankly, the bottom line to that is it saved a lot of advertising dollars, because all of those extra words, of course, cost, and good sense prevailed. So this particular change will take place September 1, and that certainly should help us a bit with advertising expenses, and it's one of the newer changes that was signed into law. Okay, let's move a little bit into what's happening in our industry. First of all, being in Texas, you could not be in a better market. And I know you heard me say that at the first quarterly update, the second quarterly update, and you're hearing me say it again. But what I always do is give you the specifics on where that's coming from. And starting right out, let's talk about rental property, because we tend to focus more on residential. The Dallas-Fort Worth and the Houston rental markets are in the top 5 most robust multifamily markets in the nation. In fact, nationally, Dallas-Fort Worth ranked number 2 and Houston ranked number 3 with the most multifamily units going up. Number 1 was New York. But just to give you an idea, in the DFW area, there is a 61% increase from 2016 in multifamily market units being constructed. In fact, it amounts to 24,960 apartment units that are expected to be delivered this year in 2017. And in Houston, 17,960 new apartments going up. We also had Austin hit the top 20. Austin is number 13 in the nation with apartment units going up, and San Antonio, number 14. So those of you that are in property management, those of you that are investors and certainly involved in real estate in whatever direction that it coincides with multifamily, we are building in our state of Texas multifamily units, and frankly leading the nation in that we are in 2nd and 3rd place nationally. And for those of you that have an interest in property management, just a little reminder that the property management course we offer for SAE, which is that first renewal that our agents need once you're licensed, a property management class might be a good suggestion for you to take if you have that interest. And those of you in MCE, you can also take property management as one of your electives along with your Legal 1, Legal 2. So let's move over to San Antonio for just a minute, because this was just in the recon news and pretty exciting for San Antonio. There will be an $83 million multi-use office building built right next to the City Hall in downtown San Antonio. And it is going to be a 21-story development. There will be residential apartments to the tune of 305 units, and as well a commercial office tower and a multi-shopping market center. And so those of us in the San Antonio region, there will be a new skyscraper downtown that is a commercial building. And for those of you that are interested in commercial, we definitely have commercial marketing. That's an SAE course, and as well you can use it as an elective for MCE. Well, let's go over to the residential area for right now. On the residential side, my goodness, DFW is up 11% from 2016 on single-family homes. It's been a record-breaking year, certainly for Dallas, Fort Worth, and most definitely as well for Houston. All of licensed agents get their local association magazines, newsletters, as well as our research center sends you a wonderful email newsletter once you're licensed, and you also get Terra Grande magazine, which is outstanding. But they've all given us such great news about what's going on in our residential market. The North Texas record of home sales for July were just incredible in that there were 10,962 properties sold, traded in the month of June, and the stats came out in July, that the first 7 months of 2017 has almost hit and will definitely surpass what the all-time record in the Dallas-Fort Worth area was for 2016, which were over 100,000 homes sold last year. And the direction that it's going this year, to date, the end of July, it will break that record as well. And again, in the Houston market, have broken records from 2016 as well. I think one of the most exciting indicators of that is we know that a regular steady market is 6 months of inventory, which means homes available on the ground. If you go over the 6 months, it tends to move into a buyer's market where sellers are a little more concerned and desperate about getting their properties sold. Below the 6 month, we move into more of a seller's market. And as of just last month, across the state, on average, we're still below the 40 days on market. 40 days on market to get a house sold. And in the Dallas-Fort Worth area, their stats show that as of July, their averages were 35 days on market. So, my goodness, anytime we get into the 5-month inventory, the 4-month inventory that we've had the last year, and certainly this year, 3.5 months, 4 months, we still have a very outstanding market, very enviable of other states that are out there. The median sales price as well has gone up significantly in the Dallas-Fort Worth area. In fact, 9% for the month of July, and the median price up to $250,000. And all of that information we know is so very valuable in that you're sitting down with your homeowner, and whatever region you're in, they've read the news, they've heard the media, and most assuredly they expect us, the real estate professional, to be up to date on what's going on in the marketplace. So bring down those recon newsletters, bring down the information that you get from your local associations so that you are literally suited with the information that will make you be more credible and certainly a listing or a selling specialist. I want to also bring to your attention that we are so very, very happy to have Dr. Jim Gaines with the Real Estate Center come and kick off our January 1st update of the year. And Dr. Gaines, for all of these years, has been known to go around the state of Texas and let real estate licensees know what to expect for the coming year. And we are so pleased to know that the 1st of January, he will be speaking right here in our studio to anyone and everyone that goes to our website or goes to a counselor and get yourself registered. It's complimentary, and it's something that we love to do for our customers. And you'll get the kickoff to 2018 Economic Update by Dr. Jim Gaines. Well, Texas major metros to add 130,000 homes. The fastest growing market, according to Trulia, is the Austin market. And Trulia say that the Austin market will add 30,000 homes this year in 2017. We know that the Austin market butts up to the Round Rock area, Williamson County, and that particular area is also a huge, huge growth area. And the major metros being Dallas, of course, Houston, Austin, San Antonio, and 10% of national new construction is coming out of 10% of the nation is coming out of the metros that are Dallas, Houston, Austin, Phoenix, and New York. And that was fresh off the press from Trulia. So new construction, very, very robust in our state. So how do we keep up with all of what's going on in our business? I absolutely can tell you, and I hear from top agents, they never stop taking courses, they never stop learning, they never stop reading. They know that in order to be on top of their game, that there are so many wonderful seminars, coaching, that keeps you abreast of what's going on in the industry and makes you more confident with what you're talking about when you're sitting with the homeowner and you want to talk about staging or you want to talk about pricing and negotiation. We are most definitely at Champion School of Real Estate in there, hands, feet, giving you every possible course that will help you increase your bottom line. What we also know is once you make the transition from whatever career you were in into real estate, now you take your courses, you pass your national state exam, you get the license, and then you go to work and you start thinking, oh my gosh, I didn't really know that much about restricted, unrestricted property. I didn't know that much about selling through a trustee of an estate. And you start thinking, maybe there's things that are possibly going to get me into trouble. Well, yes, there are. And in all of our courses, and as well as the A&M Legal 1, Legal 2 course, they're geared to remind you on a daily basis what you can and can't do in order to retain that license and stay out of trouble. So the area that I want to hit until we finish up at 10:15 is literally information that's in the License Act. There are about 36 separate areas that are listed in the section that I'm going to give to you in just a minute. But in between that, there's that gray area called acting incompetently or negligently in the role of an agent. And that's where getting your education, certainly whether the delivery is classroom or online or live broadcast, the way that we are doing our quarterly update today, it's paying attention, being tuned in so that there will be something that hits you that will make you think, well, maybe I could have done that particular transaction a little differently, or maybe you actually did something that was not actually legal. So as I go through the next part of our program, I'll give you some examples of the ones I picked out from the License Act that time and time again our agents will bring up in the classroom and say, was there a better way of doing this, or should I not have done such and such? So for today's update, my goal and hope is that possibly it motivates you, prompts you to go to section 1101-355. You can Google the Texas License Act, aka Occupation Code for Real Estate Brokers, and you'll see everything is in there, from how many hours you need to get your license to what I'm going into today, the different ways that we can frankly either get our license revoked, or we might get a reprimand, or we might get a suspension. So even though this isn't in that particular area, I want to start off by talking about a business entity, and I want to mention something about teams in real estate. But first of all, let me just read you a couple of sentences from section 1101-3.355. To be eligible for a license under a business entity, you must have a designated broker. There must be an active broker. And there must be proof of E&O, errors and omissions insurance with a minimum annual limit of $1 million for each occurrence. And if in fact the designated broker owns less than 10%. So just last week someone said to me, well, why, if the designated broker, why is this only appropriate if the designated broker owns less than 10%? Well, I guess the idea is that that designated broker owning less than 10% may not have their eye on what's going on day to day in the business as much as a broker that was in ownership of 100%. But whatever the thought process was behind that, yes, you need E&O insurance. Without the E&O, and if you're operating as a business entity, for sure, that would be a violation. And then moving on down to a broker's license, every time the legislation meets, every time there are opportunities for TREC to go in and discuss different rules and regs and policy and changes in statute, the word broker comes up over and over and over again. Just getting your broker's license is very simple, and with this particular new change in the rule and the law, it just became simpler. If you have a college degree, and the new rule in the occupation code simply says college degree, you have fulfilled the additional 630 hours of elective courses. Now, in the past, TREC would look at your college degree and look at courses like English, history, accounting, government, and say, yes, those work, those work, those work. No, this doesn't, this works. But now, just recently, the change is if you have a college degree, you have fulfilled the 630 hours elective. And the 270 of non-elective, which we used to call core, we now call qualifying, or QE. Those particular courses will count towards your 270. And again, because some of you are fairly new, or some of you have been in the business a long time and you've forgotten what these particular acronyms mean. Your basic real estate principles 1, principles 2, agency, contracts, promulgated forms, finance, property management, powerhouse marketing, investment strategy. Those courses add up to what you have to have in the 270-hour range that are called QE courses. The fact that you have to take those to get your license and to get it renewed, the fact that so many of you have been in real estate for quite a while, I'm going to just about promise that you have the 270, and if you have that degree, you could sit and get your brokers to be a broker associate. You could open your own office, but you're associating with the company you're with right now. We know the general public just adds a little credibility to you when they see that you are a broker associate. And therefore, the other requirement that you need to know is you must also take a QE elective, which we used to call core, called real estate brokerage. And you have to take that course at least 2 years before you file your application to sit for your broker's exam. And so the new part being that with a college degree, you've got the 630 hours. And you're good to go with your 270 QE hours as well. Okay. Oh, and a footnote, that brokerage course is not broker responsibility. It is brokerage. Now let's talk about this wonderful positive subject on things you can do that are prohibited and that might get you into trouble. The very first one that I picked out is one that has a thread that goes into this particular part of the statute 2 or 3 times. And it has to do with paying a commission to someone who's not licensed. First of all, you can't do it. There is no such thing as a bird dog. You have to make sure whomever you're giving a referral fee to or splitting your commission with is a license holder. Now, that licensee could also be someone from another state, as long as, again, they have a license. So you have a spouse working in the office with you, and yes, they can certainly do your day-to-day business planning. They can do office tasks, but be sure they don't move over into that area where the task they are doing should and does need a real estate license. So that particular thought process comes up regularly over and over. And you also know that you must be paid always through your sponsoring broker. We know that there are forms the title company will give to your broker that if they sign, it says yes, your compensation can be split at closing, but most definitely you would need that form at the title company in order to comply correctly with the way the law is written, that you're paid through your sponsoring broker. Okay, so the very next one after that, one more time, is specifically a sales agent may not pay a commission to a person except through the broker that is sponsoring the sales agent at that time. And a broker and any broker or sales agent appointed under this section who acts as an intermediary may not. And just a reminder as well, another thing you cannot do, if you're acting as an intermediary, you're in the same office with the agent who's either representing the seller or the buyer, and you're, again, representing either seller or buyer. You can overhear conversations, office meetings where there's open talk, shouldn't be, but open talk about the seller's desperate, even if you know that, and you're representing a buyer. We know that under the License Act, you're not allowed to disclose the minimum or a lesser amount the seller's willing to accept on his list price. And at the same token, if you overhear that the buyer is willing to pay more to that seller on that in-house listing, and you're representing that buyer, because it's intermediary, you are not allowed to disclose that the buyer will pay more. That's in the License Act. And I'm going to move on down to my number 4 favorite. And as well, just to remind everyone, if you're in office right now that you've tuned in with us today, because we do have companies that do office meetings now on Tuesday morning in order to get our wonderful complimentary information into their offices, just pulling out this section is great conversation for discussion with your agents. The next one that I pulled out actually comes attached with a change in the law for providers, and it reads like this. If you entered a plea of guilty or nolo contendere to, or you're convicted of a felony or a criminal offense involving fraud, and the time for appeal has elapsed, or the judgment or conviction has been affirmed on appeal without regard to an order granting community supervision that suspends the imposition of that sentence, if you had one of those offenses and on your application to become licensed, you did not answer truthfully, then chances are you won't get a license. And then a little bit later, we find out if you're licensed and there was an issue that happened while you were licensed, you only have 30 days to let TREC know that you were found guilty of this particular fraud. So if you want to see how this sort of comes into play, when I was at the commission meeting just 2 weeks ago Monday, there were a couple of licensees during that meeting who the legal staff had already heard their particular case, and yet they have the opportunity to one more time be in front of the commission and say whatever they would like to say and plead for a different end result or suggestion by legal counsel, and they are able to do it that day before the TREC commissioners vote what to do. This comes up over and over again, is why did you lie on your application that you had no criminal offense in your background? So when I said how it applies to providers, well now, under this particular current rule, they've even added more where the provider must disclose on our student agreement that if any of our people coming in to get their license, or certainly renewal people, if you have a criminal history, please check with TREC first before you go any further. If we don't give you that disclosure, then, and we would have done it anyway, and we've already done it anyway at Champion School of Real Estate, we give you your money back. But there is a moral character form that's on the TREC website, and you can pull that off, send it to TREC, tell them what your particular issue was in your history. Don't assume you're not going to get a license. Just go forward with filling out the form and see what they say. And but I can again restate, if you lie, you're going to have a difficult time getting a license or renewing your license. You must for sure be truthful on that form. And there is, again, the TREC moral character form on the TREC website. My number 5 is if you procure or attempt to procure a license by fraud, by misrepresentation, or deceit, by making a material misstatement of fact on the application for a license, then you've now violated another part. So there are multiple violations that can happen with one particular offense. The next one that I pulled out is failing to provide within a reasonable time information requested by the commission, which relates to a formal or informal complaint. And again, if you get a letter that says, we want to come and visit you in your office, look at your files, talk with you, now, don't assume everything's going totally downhill. But if you're also asked to reply, know that there is truly no specific time limit, but do know that you must reply right away or there's another violation. Whatever you did that someone reported in writing Okay, now TREC's following up, but don't delay in replying. And another delay that sometimes comes up is if you gave them an NSF payment and they say make the funds good, then for sure make the funds good really, really fast. The next one that I pulled out is failing to notify the commission no later than the 30th day after the date of a final conviction. And that's a footnote to the one that I mentioned earlier on the application, where do not misrepresent that you have a fraud or some other issue in your criminal history. But again, now you're licensed and you have had a problem, an issue, and during that license period you neglected to let TREC know about it. That's not good. That's another violation under number 6. And then we have under 1102, engages in misrepresentation, dishonesty, or fraud when selling, buying, trading, or leasing real estate in the name of yourself, the license holder, the license holder's spouse, or a person related to that license holder. And it says literally within the first degree of consanguinity. It's a good word to say over and over again. This is fairly new, but used to be just the license holder's name. But if you are helping your relative buy a property and possibly you have information that could help them, but it's dishonest what you're planning on doing, or what I call fast and easy, then don't do it. And that's literally under the License Act, and they specifically pull out your spouse and sort of next of kin in so many words, and you're doing something that engages in misrepresentation. Another one is failing to use a contract form required by the commission, and I want to as well remind everyone that builder contracts are fine because they're required by the principal. So if the principal were to require a different contract, certainly one drawn up by an attorney, that would be fine. But if you came from another state where they don't have this requirement, and you assume in Texas that you don't have to use the Texas Real Estate Commission mandatory form, then that would be incorrect. We are obligated to use our contract forms. And if there is an addendum that is mandatory, notice I'm not using promulgated anymore, then you can't write up your own addendums. So I always suggest to our wonderful students, agents, have a list of those mandatory forms. You can pull them right off the TREC website and have your list and know these are mandatory. So I certainly won't be going to my office manager or my assistant, and I would not be making up my own statements in here. And again, we can't do that, period. We can only write down what our principal would like for us to say, but if there is a standard form for that, then we don't go that direction. We use the mandatory TREC addendums. And this is sort of just a catch easy for every, just an area over here, acting negligently or incompetently, and it just is a standalone statement. If you make a material misrepresentation to a potential buyer concerning a significant defect, including a latent structural defect, the key word here is known to you, the licensee. Well, we all know that that would not be something we should be doing. When in doubt of whether or not this might be of significant information to your buyer, just know if you have to wonder, is this significant to a buyer, just tell them. And if it's not significant to them, no problem, but you've done what you needed to do. So, for example, you know, in the Houston region, certain neighborhoods that flood, or in the Austin region or the San Antonio region or Dallas, Fort Worth, down by the Trinity, you know, but now it's nice and dry and everything looks good. And very possibly the seller might have not told the truth on the seller's disclosure, but you know for a fact that this area floods. Yes, that is a known defect that you, the professional, should know and disclose. And I know the question that you're saying is, well, what if the seller said don't disclose it? I would suggest you let the seller know and let yourself be reminded that no sale is worth that seller causing you to lose your license. So disclose, disclose. And disclosure, of course, means in writing. If you make a false promise that is likely to influence a person to enter into an agreement, let's say a sales contract, when the license holder is unable or does not intend to keep that promise. And one that comes to mind would be an agent who says, if you use me to list your house for sale, when you're ready to find your new house, then I will cut my commission, give it to you in closing cost. Okay, that's fine, as long as you do it. But if you promised to do it, and oh, those sellers were so difficult to work with, I earned every bit of this commission, and now I'm going to show them that house to buy. I'm sorry, I can't do that. It's been too time consuming. Well, you made a false promise, and chances are they're going to be really unhappy about it and very possibly report you. That's just an example. Failing to make clear to a party to a real estate transaction the party for whom the license holder is acting. So we hear regularly in court, possibly the agent is on the witness stand and they say, well, who were you representing? And it's because maybe they were doing intermediary without appointments and they didn't really understand how it works, or maybe they were an appointed intermediary, but because they were representing the buyer and it was within their company, they wanted to also help the seller. So please, please know who you're representing in a transaction and make sure that your actions demonstrate that, because that is another simple little letter right there of the law. If you receive compensation from more than one party to a real estate transaction without the full knowledge and consent of all parties to the transaction, we can get referral fees, let's say from an insurance company, but it all must be disclosed in writing. And according to the License Act, with the consent of all parties. So consent, again, everything in writing, in writing, in writing, in writing. And our contracts and our addendums are a perfect place to disclose all of that. Fails within a reasonable time to properly account for or remit money that is received by the licensee holder and belongs to another person. And maybe you're thinking, well, how does that happen? We receive earnest money. We know the earnest money needs to go straight to the title company or to the escrow person in charge. And as well, we receive option money. We know that option money goes to the seller. So keeping those in our hands for any amount of time is certainly not a good idea. A rule of thumb is 3 business days, that it goes from your hands to the escrow officer within, or to the seller within 3 days, or certainly even faster than that. Commingling money that belongs to another person with the license holder's own money. So you decide to work in property management. There are some homeowners that want to lease their property and they have asked you to be the leasing agent. Indeed, that money goes straight to the owner of the property. It goes or into a separate escrow account, and you do not commingle the two at all. And then one more time. This is how many times on our list? Number 11, paying a commission or dividing a fee to someone other than a license holder who is not licensed. So definitely that must come up a lot. And indeed, they want to make sure we know you cannot do that. You cannot do that. You cannot forget or not put a definite termination date into any of your forms. You can't say this will go on, this listing will go on until either party gives a 30-day notice to the other party. You must have, under the License Act, Occupation Code, a definite termination date. And another one that is my number 19, if you accept, receive, or charge any kind of money, it must be disclosed. So I'm going to read it now, the point blank straight sentence. It says, if you accept, you receive, or you charge an undisclosed commission, rebate, or direct profit on an expenditure made for a principal, you can have your license suspended or revoked. So don't get with the repair company or the new roofer and say, because I'm recommending you, up the price a bit and give me a couple $100 back. Obviously, good ethics tell you that's not the way that you want to work as a professional, but it's also against the License Act. If you solicit, sell, or offer to sell real estate in any deceptive practice, that's another standalone. That's my number 20, in a deceptive way. Let me give you just an example of that. Your friend is selling his property, and a buyer comes to him. He feels like he shouldn't sell it directly to that buyer himself. He's just thinking, not a good idea. And my friend is a licensed agent. So he calls you, the licensed agent, and says, will you be my listing agent? I already have the buyer. I think I need to maybe have a little separation here between myself and the buyer. Can you find a buyer's agent for this buyer? And by the way, the buyer's willing to pay da-da-da-da-da. Just write it up and have your friend be the buyer's agent. The buyer's never met the agent that's going to represent him. The agent working for the buyer never did a CMA. There's an example of being deceptive, misrepresentation, and very close to violating a lot of these particular areas. And your good sense just says no. Buyer needs to be met, buyer needs to have a CMA, and it needs to be done the legitimate way that you've learned how to do it all these years. Acting in the dual capacity as broker and undisclosed principal in a real estate transaction. So if you're selling, leasing, renting your own property, you of course know that you must disclose in writing that you're a licensed agent in the state of Texas. And we would never do this because you know it's against the License Act, but you can't guarantee a profit on anything that a particular buyer purchases from you. And one more time, I'm going to leave you with number 26, which is, or I'm going to leave this discussion with number 26, which again hits, establishes an association by employment or otherwise with a person, and they're not licensed, but they're expected to act like a license holder. So when, for example, you thought you only violated one particular part of the occupation code, but it's hit many times, then they can add up violation after violation after violation. So I really wanted to stress that one today because it must be that is an area that TREC's seeing a lot of violations. You use a family member and they come on board just working for you in the office as an office helper, but in fact they end up moving into the real estate side and they're not licensed. So one other change that just happened, I told you that promulgated forms are now called mandatory forms. And as well, all through the License Act, it's written attorney at law. And they changed attorney at law to lawyer. So instead of seeing attorney at law, we're going to see the word lawyer. Those were just my favorite picks of items that we need to be reminded can get us in trouble. So let me recap very quickly what we've learned today. We've learned that on construction, we're in the top 5 of the nation for new home construction. We've learned that our days on market are still very, very good and solid for sellers. We've learned that our rental market and apartments are still being built left and right. We have all of our major metros that are rocking and rolling and are being noticed by all of the USA. I brought over just a couple of things since we've done our time together, our official time. So now I can tell you about a couple of things that I think you'll like to know and that might help you in your business. David Winans out of the Dallas region has a super book that has every region in Texas, beautiful pictures, updated information about how truly awesome Texas is. It's a great book to have in your car that as you're driving around, your buyer would love to thumb through this. Maybe it's a great little book to give to them. And we do have those at Champion School of Real Estate for sale. They're also part of your MCE course if you are in the Success Strategies course. But it's a cool book. We have our career fair all over the state of Texas coming up September the 29th. Please let your local campus manager know you're going to be there. And you set up your kiosks. Our students, please come on September the 29th and visit all of the companies that will be there to get your information and they will be happy to set up appointments to talk to you. That's September the 29th. I was excited to be able to help a lot of our students with 30 Days to Success. 30 Days to Success is what to do once you're licensed, how to make money in real estate, and you also get the video that goes along with this for 30 days. This year we packaged it, this fall we packaged it with our business etiquette course, and this is $79 for our students for 30 Days to Success. Package with business etiquette is $179. This jumpstarts your professionalism and who you are in real estate. We have one other. We love it when we're able to take media like came in the Houston Chronicle Sunday. They focused on real estate, only they said it takes about 2 years to get your license. We know it takes more about 6 weeks or as long as you want. But they focused on a number of people transitioning careers, and they are Champion School of Real Estate graduates. I was so excited to be able to see all of those wonderful people and to know that we champions were a part of their success. Our goal is, with all of our designation courses, that you learn how to do a great CMA, how to be a better buyer's agent, how to work with seniors, boomers, millennials. We have all the designation courses for that. And then every quarter, I love to be able to get in front of you and say thank you for your business and tell you that you have the best teachers in the entire US of A that are teaching you constantly at Champion School of Real Estate. And I can say that because that is my personal opinion on our amazing instructors, especially those that are here today. And then with our live studio allows the teacher to teach while you're sitting at home or wherever, maybe your office, like we did this morning with office meetings. And then we have interviews with superstars, Dr. Jim Gaines. So coming up in October, in fact, it's October the 17th, we have Rogers Healy that I'll be interviewing right here via live broadcast It's free. All you need to do is go online, www.championschool.com, register, or have one of the counselors register you. Rogers is one of our wonderful students, graduates, real estate agents in the Dallas region. He also has his own office. He's the one that Fox News and the local stations interview on real estate expertise. He's also an agent to the stars in the Dallas area. And I'm so excited to be able to interview him in October. And you will be able to hear Rogers Healy tell you how he got started in real estate. He is a millennial, and what gave him his steps to success, and frankly the things that he had great difficulty having to overcome. So with that being said, I'm going to say goodbye until next time, which will be October when I see you with Rogers Healy. And we have a